Inter-party review, or IPR, has fundamentally changed the way patent disputes are handled in the United States. Effective use of IPR by defendants in certain circumstances has effectively turned the tables on plaintiffs and put the patent owner on the defensive.
In the 3 years since IPRs have become available, the number of filings has trebled. In fiscal year 2013, there were 514 petitions filed. Last year, there were over 1,700 petitions filed.
The Patent Trial and Appeal Board has instituted IPR proceedings for more than 70% of petitions that have been filed to date. Now, some of those IPR proceedings result in settlement. For those that don't, the vast majority of claims that are challenged in IPR proceedings are either canceled unilaterally by the patent owner or held to be unpatentable by the board.
In a typical district court case, it could be many months to years before a district court will rule that a patent claim is invalid. Contrast that to the PTAB, where they will deliver a final written decision in 12 months after institution.
IPRs involve a more focused analysis of the validity issue than district court litigation. Each IPR is decided by 3 administrative patent judges. Each of these judges has a technical background in science or engineering and is an expert in patent law. Some of them have even practiced patent litigation in private practice before becoming an administrative patent judge. These administrative patent judges decide one issue, and that is whether the challenged claims are patentable in view of printed prior art.
In district court, on the other hand, those issues are decided by a jury of lay people who are also deciding not just validity, but other issues such as infringement.
Successful IPR can eliminate much of the costs associated with litigation. The compressed time frame for IPR proceedings means lower costs. In district court litigation, discovery is often a huge burden, and the procedures can account for a large portion of attorneys' costs and fees. There is some discovery in IPR, but it's limited by statute and much more limited than district court litigation.
Additional cost savings are also available in an IPR due to the fact that the final oral argument is normally limited to a few hours, as opposed to a trial in litigation, which could go on for several weeks.
By seeking to stay pending litigation, IPR challengers have the opportunity to quickly and inexpensively resolve the dispute, where the board determines that the asserted claims are unpatentable.
Now, one of the key factors that a court looks to in granting a stay is the timeliness of the motion. So you want to get that petition on file and the motion to stay on file as quickly as possible. Before filing a suit, a patent owner must consider the possibility of an IPR. Factors to consider would include which parties to sue, in what order, the type of parties, which patents to assert, which claims of those patents to assert.
Now, before litigating, a patent owner would be wise to run a thorough prior art search and determine the vulnerability of the patent to IPR challenge. And if there are potential problems, the patent owner should consider putting their own patent into re-examination or reissue to clear up any potential problems.
As a defendant, you simply must consider an IPR when you find yourself in a patent litigation. The IPR mechanism allows you to leverage favorable settlements, and your likelihood of success of invalidating claims is much higher than in district court.
IPR is here to stay and has revamped the landscape of patent litigation. There are many issues that are unique to IPR that must be considered and dealt with as a central aspect of any patent enforcement or defense strategy. Identifying and dealing effectively with these issues is critical to our clients' success.